Hello and welcome. Hello and welcome. We're glad you're here. This is a webinar that focuses on fair courts and the environment, and we're just really glad you're here. So what I'm going to do is I'm going to start out with an overview of things. I'm Catherine Terser from Common Cause. Welcome. We're so glad you're here for part two of our series that focuses on judges, Judicial Philosophy and the Environment. We're just really glad that you're here. And this session, you can actually get one CLE credit. So we're really glad that there's a credit for folks that are trying to accrue that as lawyers. And welcome, and we're going to get started. So what I'm going to do is I'm going to introduce the panelists. We're going to go through some of the goals that the Ohio Fair Courts Alliance has. We're going to do an overview of, what the summer series is and what happens in September. So we're going to hear from Chris Tavenor on that. Then we're going to have this is Chris Tavenor, talk about standing and home rule. Randi Leppla is going to talk about court administration and judicial activism. And actually, one of the things I like the best about these things is time for discussion and question and answers and spending a little bit of time actually discussing all of the different ideas that we're going to cover. So with that, I would like to introduce you to Miranda Leppla. Randi Leppla, she has a law degree from the Morse College of Law at The Ohio State University. She is currently the director of the Environmental Law Clinic at Case Western University. Now, prior to that, she was the VP of Energy Policy and the lead energy counsel for the Ohio Environmental Council. And speaking of the Ohio Environmental Council, we also have Chris Tavenor. Now, Chris is the Ohio Environmental Council's general counsel. Um, counsel and counsel, imagine putting that together. It's got to be a hard day for him. Now, many of you will remember Chris from our first session of this series. And I want to remind you all that not only did he go to law school at Morse College of Law at Ohio State University, he also is an author. He writes science fiction fantasy series under the name C.D. Tavenor. And then we also have Jessica Dickinson. Now, Jessica Dickinson is the program director for the Ohio Fair Courts Alliance. I'm part of the Ohio Fair Courts Alliance, and I'm Catherine Terser. And with that, they can all tell you much, much more about themselves. I'm going to hand it off to you, Jessica Dickinson, to tell us a little bit about the Ohio Fair Courts Alliance's goals.
Hi, everyone. Thank you so much for joining us. Quick point of order. If you have questions for the panelists, please go ahead and put them in the chat. And when we get to the Q&A portion, we will take those and Catherine will ask our panelists. So we're collaborating with this three-part summer series with the Ohio Environmental Council because they are one of the founding members of the Ohio Fair Courts Alliance. We focus on civic engagement and education around the courts, most specifically the Ohio Supreme Court. We also focus on judicial elections, the role of money in judicial elections, and we also work on criminal justice reform, such as bail reform. So really, we want to raise public awareness about the importance of our courts and voting for judges and getting information for judges. You can see we want to build a stronger coalition and we want to try to pass stronger rules to, limit the influence of money and special interests in judicial elections, which is increasingly becoming a problem. But that's who we are. So I believe Chris is up next.
Yeah, thank you, Jessica and Catherine, for that great intro. Catherine loves promoting my stuff that isn't related to my job, and I love her for it. So I appreciate you always, um, even though I tell you not to. Yes, so today is our second session of our series focused on the intersection of the courts, judges, and the environment. And today we're talking about judicial philosophy. We've kind of selected four topics that really kind of intersect with environmental issues in a few really interesting ways. And then Next month, we'll be focused on the intersection of state agencies, the courts, and your utility bills. And just as a quick reminder for folks who are paying attention to OEC's other events, just a reminder that we have our law conference coming up on September 25th. Registration is live for that already. Would love to see you all there. If you are an attorney who wants CLE credit, we will have a few poll questions throughout just to track your attendance. Those of you who are attorneys are used to that sort of thing. We will have a survey for you to fill out at the end to kind of lock in that credit. It's free. If you're an attorney and you want that CLE credit, thank you for joining us. So let's go on to the next slide and we'll get started. Okay, so I'm going to have this slide probably in each session just to remind us of like what all we're talking about. And, so last month we kind of gave a little bit of a really high level overview of how different types of environmental cases move through the courts. And so today we are almost fully laser focused on the state courts. We'll talk a little bit about the federal courts, but we're mostly going to be talking about state courts. We won't really be talking too much about everything that goes on in the middle, the administrative agencies, governmental entities, and all those sorts of things. So just to really kind of ground us on where we're talking about some legal philosophies and how they kind of play out at the state court level here in Ohio. Next slide. So our first big topic is standing. And standing, if you're an attorney, you probably know what standing is in the context of the types of cases that you do. Maybe you're an environmental attorney and you have a really good grounding in what standing is. But for those of you who are not attorneys, standing is one of those issues that when I talk with my friends who are not attorneys, they have no idea what standing is. Standing is something that is like one of those very specific procedural legal issues that really underpins how judges approach and assess whether or not someone can even bring a case. Those of you who are attorneys know this, but what we want to talk about briefly here and then get into our discussion is really the different sorts of issues that can come out of standing and really how judges have a lot of latitude in kind of narrowing or broadening what standing is. There is a little bit of a historical trend of generally narrowing standing over time. And we can talk about that a little bit more if people have questions, but I want us to focus kind of on what standing looks like in Ohio, and then tease out a few examples of how kind of a judge's philosophy can kind of end up playing into how they might end up ruling on standing. So in Ohio, the basic standing test is a litigant, someone who's suing another party, must demonstrate that they're injured, that injury is fairly traceable to the defendant's alleged unlawful conduct, so the person that they're suing, and that the lawsuit, like that injury is likely to be redressed by the requested relief in the lawsuit. So that is the basic element of standing. Those of you who are attorneys will probably have seen this sort of thing before. But one of the things that I wanted to kind of pull out before we kind of dive into some of the other issues here is that standing can also be modified by statute. So there is this basic common law standing test, but the legislature can actually provide standing to people in very specific ways. Though in general, they like to not do that. They like to take that away and not give people standing. And there are examples of people losing standing over time in different ways. But I just wanted to note that we've got a very clear statement from the courts, but also from the legislature that standing may also be conferred by statute. But standing is a foundation to what how any case moves, and how a judge approaches standing is really relevant to how they manage their docket. Next slide. So in the environmental context, there's a recent case from 2018 that really kind of teases out some of the ways that how a judge looks at a case can really impact whether or not they find that someone has standing. So when we are bringing lawsuits and we need to really establish standing, we have to look really closely at the harm that someone is experiencing and link that to the alleged misconduct of, say, a governmental entity or a polluter. But those of you who maybe environmental scientists or know a little bit of thing or two about environmental issues, sometimes harm is difficult to trace. Air pollution doesn't really follow specific pathways. Same with water pollution. And there's a lot of science that goes into it. And that can really impact whether or not a case can really be presented to a judge in an effective way. So there is a case from 2018 called Food and Water Watch, where an organization was suing over the impact of a regulation on and what the impacts of that regulation would have on the individuals, the plaintiffs. And so what I'm noting here is you've got this judge that is they ended up not having standing. The court in this case, this went up to the Ohio Supreme Court, said these plaintiffs don't have standing because they were just expressing a concern for their health and that the health problems were speculative and insufficient to establish standing. But I'm kind of highlighting that because what is speculative and not speculative is pretty flexible, and how a judge approaches that question can really matter. And so we're going to move on to the next slide, but I really want to kind of just like note that for folks that like what is speculative matters. And so we're going to now do the first poll question. If that is up, I think I had another slide before this, but I must have moved them out of order. So we'll do the poll question now. What is the test for standing in Ohio? There is a right answer here. I just gave it a little bit ago. We'll give people just like 30 seconds to answer this, and then we'll move forward. While they're answering the question, Jessica, if you want to move to the next slide. So,
Chris, I'm going to end the poll. You all ready?
yeah, that works.
Here we go. And the results I'm sharing.
All right, everyone got it except two people. Great job. Good work, everyone. That's what the standard is in Ohio. So a few questions for people to just be thinking about as they think about this test, though. So how open to interpretation is fairly traceable? That's where I'm like, when the Supreme Court said, oh, the harms are speculative. That there are they didn't really give a bright line rule for what that means. And so whether or not something is speculative can really turn on how a judge is presented with the evidence, but also what knowledge does the judge have to actually vet the evidence that's before them as well. So you can think about whether or not a judge has experience or expertise in a particular issue, such as if they worked in, a really fact-based field before they became a judge, they may be able to really dive deeply into the sort of environmental factors that could play out. So what does it mean to have such a personal stake that they are entitled to have a court hear their case? That was a line in one of the cases I had on the screen earlier. Such a personal stake seems pretty subjective to me. And I already talked about this expertise question, to determine whether or not the particular environmental harm will be redressed by the remedy that they're pursuing in the case. These are all questions that have flexibility in them, and that's one of the things that I just want to kind of emphasize here, that standing on face value may seem really obvious, but there's a lot of room for a judge to make a call on whether or not they're standing. And that importance we'll get to a little bit later when we get into one of Randi's sections. Moving on to the next slide. So the other piece that I want to tease out here from a little bit of a historical note is that I always think about in the context of standing is what our current rule is for standing, this injury, redressability, traceability, that sort of test. That is, it's built off of federal framework, and then the state, Ohio, has a very specific standing framework too that is very similar to the federal one. But I love this little historical fact because it's also a really sad one, which is that back in 1972, there was a case before the U.S. Supreme Court where Justice Douglas was a single dissenting opinion. Well, there were other dissents, but he was the only one who joined this particular dissent, where he posited forth the idea that standing should be significantly more expansive than it is today. And his dissent, he was pretty much like, look, there's all of these different issues where if we had a more expansive definition of standing, um, we could really have maybe a little bit more of a robust concept of um, defending, the environment from harm. And so he was actually advocating for the idea that inanimate objects or plants or trees or environments could have standing that people could sue on their behalf. And he actually made at that time a very good comparison where inanimate objects have been parties in litigation, such as boats. And he also makes the point that corporations have been given standing, and those are inanimate objects. So the reason why I bring this up is to really emphasize how laws in our legal system can really shift based on what judges are making what decisions. If four additional judges had joined Justice Douglas in this opinion, the law of the land in 1972 would have been trees have standing. That's just four additional judges would have had to join him in that. And I think that's important to note when it comes to how, we have this judicial philosophy of stare decisis where like decisions are supposed to stand, but judges do overturn past precedent. We've been seeing that over the past few years pretty aggressively. And just like there is a world where our current standing system isn't necessarily the standing system that we have in the future. Next slide. So the next topic I'm going to talk about before I turn it over to my colleague is home rule and the environment. So many of you may be familiar with the concept of home rule casually, or maybe you do know it intimately. But home rule is uh, a guarantee in the Ohio Constitution that municipalities shall have authority to exercise all powers of local self-government and to adopt and enforce within their limits such local police, sanitary, and other similar regulations as are not in conflict with general laws. So what that's essentially saying is, unless the state passes a giant general law about an issue, then local governments have the authority to do that work themselves. That's the simpler way to say that. What that actually looks like in practice and in the environmental context is really dictated, though, by how the Ohio Supreme Court and other courts across the state have interpreted this section of the Ohio Constitution. Next slide. So what we had in the Constitution is some language, but then the Supreme Court has created tests that interpret what that means. And so we have these tests where the home rule, they state, a state statute takes precedence over a local ordinance when the ordinance is an exercise of the police power rather than of local self-government. The statute is a general law, and the ordinance is in conflict with the statute, which feels like a very basic kind of just restatement of that constitutional claim, that constitutional provision. But then there is a deeper test about whether or not the statute is a general law, which is like the question that doesn't really have definition in the Ohio Constitution. And what we have is the Ohio Supreme Court setting forth a test for that as well, which is that it's part of a statewide and comprehensive legislative enactment. It applies to all parts of the state and operates uniformly, sets forth police, sanitary, or similar regulations rather than just granting or limiting the legislative power of a municipality. And then it prescribes a rule of conduct upon citizens generally. So that is what the Ohio Supreme Court has applied for home rule. Next slide. So the reason why we're talking about home rule is local governments, oftentimes they are trying to set environmental policy in Ohio that is more proactive than what the state is setting. And we've seen multiple times where local governments will try to do some sort of environmental policy, and then the state creeps in and says, no, you can't do that. And then a lawsuit about home rule ensues, and then there's a determination as to whether or not the ordinance violates home rule. And there was a case back in 2025. I actually helped write an amicus brief in this case in support of the city of Athens. The city of Athens had instituted a plastic bag regulation, limiting the instances in which plastic bags could be used in businesses throughout the city of Athens. And the Fourth District Court of Appeals at the state level ended up ruling with the state. The Ohio Attorney General had sued the city of Athens, saying that their ordinance violated the state statute because there was a state statute that had added a definition about an auxiliary container being a plastic bag, and that auxiliary container definition was wedged within some statutes regarding how waste is managed in the state. And so therefore, Athens can't pass this plastic bag regulation. I don't want to get into all the arguments that were made in that case, but the reason why I pulled out this case because the Fourth District Court of Appeals actually used a different judicial philosophy in their support of their decision to agree with the Ohio Attorney General, which is this presumption of constitutionality. Some attorneys may know about this, but this is a philosophy some judges employ, where in determining the constitutionality of an ordinance, we are mindful of the fundamental principle requiring courts to presume the constitutionality of lawfully enacted legislation. And so they said that they were presuming the constitutionality of the ordinance, but they also, I think, were using this to presume the constitutionality of the statute at play. And so what we see here is that they favored what the legislature had done over what the municipality had done, and kind of veered in favor of agreeing that the state's weird definition that didn't really apply to what the city was doing, in my opinion, to be clear. They ended up siding with the state and the state legislature in overruling what the city of Athens was attempting to do. Next slide. So another one is has to do with this case, State X Rel Morrison v. Beck Energy Corp. There was a local government that was attempting to regulate oil and gas development at the local level, and the courts ended up ruling against that local ordinance, saying that the state system for regulating oil and gas preempted the local ordinances, and this is another judicial philosophy that kind of crept in, where in determining whether a conflict does exist, a court refers to the language of the statute to determine whether the General Assembly intended to preempt local regulation on the subject. So I note this because what they're saying is the court refers to the language of the statute. Looking at the statute, this is essentially they're saying you got to look at the text of the statute as opposed to maybe looking at what the General Assembly intended at the time they passed the statutory framework. And that's another moment where judicial philosophy kind of creeps into this situation. So next slide. Finally, I want to talk about an issue that just real quick, a note of case for folks that isn't actually home rule specific, but it is about a local government's. There's not the constitutional question isn't coming into play right now in this case, but there is a community called Commercial Point south of Columbus that has put in place a data center moratorium. And the data center has appealed the moratorium to the Ohio Supreme Court, arguing that the local government can't put the moratorium in place to block their data center because they had already vested rights through that application process. And well, I just want to note this because this is a very live issue. I'm sure everyone's very aware of all the data center issues going on right now, but there's this Supreme Court case right now that could determine at what point in the application process for zoning and building permits that data centers vest their right to just get their data center built, regardless of whether the local government is trying to figure out the impacts of data centers to their communities. So I would just encourage people to watch this, but how the Supreme Court kind of favors or disfavors preferencing local governments may play a significant role in how this case plays out. So next slide. So I think this brings us to our second poll question, which is more of an opinion question, just to see what people think. How should judges think about home rule? Maybe you think they should weigh local authority as generally more important than state general laws, or maybe you think they should weigh state general laws as generally more important than local authority, or maybe you think it depends on the circumstances. There are a variety of reasons for why you may think any of these positions, but the important thing I want to note is that there isn't necessarily a clear answer on how judges
Catherine,
should
can
be
you
answering
launch
these
the
questions.
polls?
Answer there would be, well, hang on. Is there something? Relaunch poll,
There we
right?
go.
Continue. Did it work?
I think you got to go to the next question because it's the first question
Okay.
again.
All right, I'm ending this poll. This
I've got it.
You've got it,
Okay.
Jessica.
Thank
Well,
you.
while people are answering that question, I think we're going to be transitioning to Randy's section now, I believe. I think that's my last slide. So hopefully the standing and home rule sections give you a little bit to think about these different sort of philosophies that we're talking about. Hopefully you've got some questions, throw them in the Q&A. But now we'll turn it over to Randy before we get into those discussion and Q&A sections.
And I am going to end the poll and then I'm going to hand it off to Randy. You all ready? Here are the results. And Randy, it's up to you to start sharing.
Great. Thank you. Okay. Can you guys see that okay? Or no, I don't think I'm up yet. 1 second. We tried
I have to say, half the battle is the technical challenges. So at
it's
some
like
point, we should talk to technical challenges in the courts.
I agree.
Well, I do think to some extent that it is Randy is going to talk about that.
That's what I
It's true.
figured. It's a good
Okay.
segue.
I think I've got it now. So I hope everyone's enjoying the discussion so far. I'm going to kind of jump into a practical aspect of things, and then kind of slide back into judicial philosophy. And the reason we're talking about judicial economy here is because this is going to have an impact on how we operate and how our judges are trying to think about the types of things that they have to go through when they are making decisions. So there are lots and lots of cases, right? Lots of cases pending. So, how does our legal system really work with the number of cases? And does it function well, frankly? And this is something that's a really important thing for us to think about because we're supposed to be able to, move forward in our justice system, but sometimes we have these lengthy waits for trials and decisions. I know Chris can tell you we were in a lawsuit and we did wait 2 years for the decision. That's a very difficult place to be in as a litigant, right? And then this lengthy time that you have for trials is really problematic as well because you are, potentially someone is at risk or they've had damages and they really need to have that, remedied as soon as possible. And so we're having some problems here where our legal system isn't functioning fast enough to, make some of those corrections. And we've even had situations where there are timelines that are required by statute, required by rule. Um, are they adhered to? We would think they were, right? But we actually had a recent example where our Public Utilities Commission was supposed to be making decisions on applications for rehearing, which is essentially an appeal back to them about a decision they made. And they are required by statute and rule to do that within 30 days. And instead of making those decisions, they were simply giving themselves more time to make a decision, which was leading to very, very lengthy, periods of time before a decision was actually issued, which would then allow that party that wanted to appeal that directly to the Supreme Court, since that is an agency decision. So we've even had issues where we do have timelines that are required, but they aren't being adhered to. And this is just a quote from Justice DeWine about that situation. So as I mentioned before, what is justice? What can it take, years to get these resolutions? So how can we improve judicial economy? This is a really important thing to think about. We do have specialized dockets. You guys may be able to think of some of these different types of dockets that we've had, but you may not know that we do have a Franklin County Environmental Court. This deals with housing and zoning. I believe it was originally created for that purpose. But it's also related to environmental safety components. There's littering and dumping cases that go before it, hazardous waste transportation, health and fire code violations, and they also deal with animal code and wildlife license issues. So these are the types of things that, if we had a more specialized docket, would we be able to improve our economy and able to improve our speed with which we are creating those decisions? Um, Specialized knowledge in a lot of these spaces is a really important thing for judges to have. We'll talk a little bit more about interpretation in a bit. But sometimes this specialized knowledge is really helpful and could help move dockets along. So, we'd encourage you to think about what other types of specialized dockets could actually help move these cases along, whether it's topical or whether it's some sort of, particular type of appeal that would go to the same place. So improving it, another just aspect of this is that proper funding is really, really important. I know no one likes to pay taxes. I know no one likes to make these decisions, but we do really need the capacity for our courts and our staff to actually handle these caseloads. And another thing that I think is really important, Catherine and I were actually just talking about this before the webinar started, is ensuring transparency and accessibility, and you do need resources for that. So it is very difficult in some instances for the public and even for attorneys to navigate some of these legal processes we have in place within the legal system. So a couple of examples for you. E-docketing systems, we've got some difficult e-docketing systems, especially at the agency level. The Environmental Review Appeals Commission, the public utilities dockets, they're just not very user friendly. And so if someone were to go on and try and find information about a case, it can be really difficult. The same is true of the Ohio EPA eDoc search, which is wonderful that it exists and that we can go find these records online, but it's really confusing once you get on there. You need different types of ID. It may not be the type of, the entity proposing a project might not be the name that you have to look up. It could be the project name. So there's a lot of reasons where that's tough. And then public records requests can be very difficult to just identify where you're supposed to submit those depending on what you're asking for. So, in my opinion, resources are really required to have these better systems so they can actually provide those better outcomes. And this is one thing that ties back to Chris's. We talk a lot, I'm talking about how we have all these cases and how this is difficult. And, my concern sometimes is that people use this and weaponize it really. I'm sure you've all heard about frivolous lawsuits. And one of the ways people talk about judicial economy as well, we can, limit standing, like what Chris was talking about. And if we limit some of that standing, then we have these, we really have this very narrow focus on what an injury is, and then some of these frivolous lawsuits will disappear. I think there are far fewer frivolous lawsuits than people like to say that there are. So, one of those things again is improving the funding, improving the type of dockets we have that then can improve this judicial economy. And it doesn't have to mean that we take the remedies out of people's hands that they should have in order to improve some of that. So I think we have a question for the audience now, Catherine. So what is judicial economy?
Randy, real quick, your slides
Yeah.
aren't advancing on the screen, at
Oh,
least for
they're
me.
not. You're not seeing them move? All right,
It's still on what is justice when it can take years to achieve resolution for me.
all right. I'm going to go ahead and reshare because it was moving on
Yep.
my screen, so I'm not
But
sure
yeah,
what's
otherwise we can do that. It is time for the next polling question.
okay. Oh, it's paused. Resume.
And the poll is up. All of a sudden, I'm thinking I'm frozen. Am I frozen?
You're not
You're not
frozen,
frozen.
but
Okay.
Randy's screen sharing is not working properly, apparently.
All right. So what slide are you on? And I will share.
Sounds great. I am on, it should be on 23. It's telling me my screen sharing is paused, so I don't know what's going on, but I will turn it to you, Catherine. Sorry about that, guys.
You'd think I could just do this, but somehow escape. I'm having trouble too. What slide are you on?
23.
23. All right. I have to tell you, folks, we are very grateful that you're patient with our technical challenges. And um, where are we with the poll? Because I guess that's the other question.
Poll is done. So we are good to move on.
All right. Well, thank you, everybody. And Randy, I'm handing it back to you.
Okay, great. Can you press, Catherine, I apologize because now you're going to flip through them for me. I don't think I'm able.
You're just going to have to tell me what you need me to do. All
Yeah, go
right.
ahead and just hit slideshow. There we go. Okay. So now we're going to talk about judicial activism or the rule of law, and we're going to talk about that in the context of Chevron deference and how we really look at how the courts do interpret ambiguous language or what they find as ambiguous language in a statute, right? So Chevron deference was really that that exact thing, was that our courts did defer to agency interpretation, right? And so this is really important in the environmental context because so much of what happens in the environmental space is through agency decision making. So this is over now. We no longer have Chevron deference. And instead, Loper Bright was the case where the National Marine Fisheries Service had regulations that required fishermen to actually pay for onboard observers, basically to collect data, make sure they're doing things right. And the lower court said, seems like the agency's interpretation of this statute is correct. And so the vessel owners still have to pay. And the Supreme Court rejected that. They said that's not what we have to do. We have to look at the language of the statute itself. And so they will no longer defer to reasonable agency interpretations of statutes. You can flip to the next one, Catherine. And so this was just, a quote from it. And so judges, very high-minded, right? Judges are to construe the law with clear heads and honest hearts, not with an eye to policy preferences that had not made it into the statute. And so there's a lot of debate about, whether or not this was a policy preference, right? When you look at the language of something, what choice are you making about it? It's still a human aspect. It's still the human interpreting whether or not that's a clear or ambiguous statute, right? So when a statute's silent or ambiguous, is the agency permitted to interpret and apply that? Or should judges take it upon themselves? And in Loper, they decided they needed to take that upon themselves and determine whether the agency action is actually within its statutory authority. You can have the next one, Catherine. Thank you. So again, judicial activism or the rule of law. Ambiguity now doesn't equal agency delegation. So they have to interpret those statutory ambiguities themselves because they do that in other instances, was their argument, right? We do this in other instances that are non-Chevron. So when we look at this as a court, now what they do is just look at it and interpret it right on its face. Next button there. And the other thing too is silence is absence, not ambiguity. What you often had was where Congress wasn't getting, all of the language into a statute, where it wasn't properly, laid out. And that's part of why we do this, remember, is that Congress can't possibly know all these things, right? They're not experts in environmental protection. Some of them maybe, but not all of them, right? And so part of this has been the theory that the agency is interpreting this as they are instructed, right? But if they're not directly instructed, now if that is absent, there is silence on that, it is no longer ambiguous and it is no longer for the agency to interpret. Instead, it's silent on it. And so we just look at the statute, and if they're not allowed to do it, that's what the court looks at and decides. So there is this caveat, though. If a statute does delegate that discretionary authority to an agency, they can do that, but they look at it and make sure it's within those bounds. And then, of course, whether it was reasonable decision making by that agency interpretation. So another question here, right? How does Ohio look at this? How do we view agency deference? So we, for years and years, had no explicit rule. And Catherine, you can just probably put all these up there, but we had a lot of different theories. And this is pulled straight out of a later case, which I'll talk about momentarily. So we had things like mandatory deference in certain case law, that you have to defer to reasonable agency interpretation. We had some that were ambiguity triggered mandatory deference, which was similar to Chevron, which was, is it ambiguous? Okay, well, if the agency interpretation was reasonable, then it defers to that. And then there was permissive, and it was just, you can rely on the expertise of the agency, but the court's responsible to interpret it, right? So as you can see, this is a little confusing, right, for both litigants, but also the courts. They've got a lot to choose from here. In 2024, I believe, or 2022, excuse me, and you can keep going, Catherine. And all these are pulled from TWISM, which we're about to talk about. So in 2022, and this is from Justice DeWine's an article he wrote for the University of Michigan's Law Journal. 19 months before Loper Bright even came out, the Ohio Supreme Court said, we're never, ever required to defer to agency interpretation of a statute. We have to make that call. So we actually Loper Brighted before Loper Bright here in Ohio. So you can go to the next slide, Catherine. So now we have this non-delegation doctrine, and this is TWISM. And so this was essentially a challenge to an Ohio statute. The engineering firms had to have a person designated as the responsible person in charge of those firms' engineering activities. And so what that this case was about was one company had a contractor as that person, an independent contractor, and the lower court said, "Sure, that's the state board's interpretation. Sounds great, seems reasonable, no problem." And the Ohio Supreme Court said, "No, not okay, not reasonable." And so they went through this process, said, "What deference should we give to an administrative agency?" And then once we know that, what does the statute mean? And so they said, this is not up to agency interpretation, right? We have to look at that first, and we're never ever required to defer to agency interpretation of the law. So we have already abandoned Chevron deference a couple of almost 2 years before the Supreme Court did for federal conversation. So these are, you can go to the next slide, Catherine. Sorry. Um, so this is, how should we, federal and Ohio agencies now proceed when they're trying to interpret statutory authority, right? So it is their job, right, to make those rules. It is their job to, put forth statutory, interpretation in those requirements. So now what are they supposed to do, right? They've got this very strange place they're operating in, trying to make sure they're enforcing and moving forward on those statutory requirements while also worrying that perhaps they're not correctly interpreting it and it could get overturned. So whether they're thinking about that on a daily basis when they are doing rulemaking, I don't know. But it's certainly something that's going to come up over and over. And so again, going back to judicial activism versus the rule of law, how has this opened the door for judicial activism if the courts are no longer deferring to reasonable agency judgment? So I think this is something that we need to think about, hard as attorneys in Ohio, as people in Ohio, because we assume, or for a long time under Chevron, that, we had agencies with expertise and it was their responsibility and their job to make sure they were interpreting that and putting in effect what the statutory language was. And so now we have judges who are interpreting that, which again, it is the job of judges to interpret statutory language. And Chevron was an outside kind of component of that, and a different test for agency interpretation. So, whether this is the right way to go or not, that's the question, right? You can go to the next slide, Catherine. And this, yeah, so now we're at a question for the audience, and this is kind of open-ended. So feel free if you'd like to pop your thoughts into the chat. But again, this is just, again, kind of wrapping up our presentation component and opening it for questions. And I'll toss that back to Catherine and Jessica, of course. But what ways do you see judicial philosophy showing up?
And this is actually the final poll question. So we can
thanks. I didn't know it was
put it
poll.
up. We can
My
put it up
apologies.
while we, yeah, it's an open-ended poll question. We can put it up while we get into our first discussion questions, Catherine and Jessica.
Well, I know for myself, the first time I really thought about standing was like in 2014 when the Ohio Supreme Court said that Progress Ohio didn't have standing to go, basically to say that Jobs Ohio was unconstitutional. And essentially, it just made me think, okay, well, what's, personal stake versus public right? And it just seemed kind of mind-blowing to me, and I was hard to understand how this worked. And so could you kind of walk us through that?
Yeah, I mean, what you're pointing out is that there is when you have too narrow a definition of standing, you can actually open the door for circumstances where someone could be doing something unlawful or unconstitutional, and there is no recourse to stop them. Now, I don't know the facts and the law in the Jobs Ohio case itself, so I'm not going to comment on that one in particular. But when I think about in the environmental context, I mean, I shared the Justice Douglas example because I don't know if I would go as far as to say that like all environmental objects or whatever should have standing, but I definitely think that given the complexity of certain environmental issues that we face, there are definitely situations in which we need a more robust definition of standing, or we're going to have environmental harms that can just go unchecked, especially if the legislature isn't taking action to also put statutory frameworks in place to protect vulnerable communities and environments from those harms. Climate change is a really perfect example of this, where we still in America do not have a good framework for dealing with climate change and the harms of climate change. Various litigation theories have been attempted. Some states are doing different things, but the harms from climate change, there isn't, and standing is really difficult to prove for some of these harms from climate change. So I think that's a good example of where like no matter what, in my opinion, a more expansive definition of standing is needed, and that could come from judges or it could come from legislatures.
Randy, do you have thoughts on this?
I do, but I think Chris covered them. So,
Okay. So, and there were some really kind of questions that the participants here tonight had to do with, like, for example, when looking at the environments in the courts, what kind of standing do indigenous nations
it's a different test, and I have to admit, I am no expert in tribal law, so I cannot explain the intricacies. But I will say that typical standing also applies, but there are some specialty statutes I know
have?
because of the special nature those tribes are recognized through.
Well, one of the things that I was checking out the municipal, the municipal league's website today, and one of the things they said they felt like home rule was under attack, and I've often felt as if municipal home rule is under attack. And could you kind of discuss, the concerns about kind of the exercise of police power, which, what does that mean exactly? Anyway, can you tell us a little bit about kind of the tension there?
Yeah. Yeah, I mean, I think, well, Randy, do you have any initial thoughts? This is a difficult question. And so, Randy, I'm curious your initial thoughts here.
Yeah, I mean, I think I'm about to answer the question. I don't know. I do think in part, I don't know if the right way to put it is under attack, right? It depends on your perspective on it. Um, I certainly think there are lots of laws that have been passed more recently that are troublesome for environmental causes because they are directly attacking some of the ability of municipal governments to regulate things that they do or do not want in their communities. So I think there are concerns about the way home rule is being applied or used, I guess, by statewide components. In relation to what municipalities, excuse me, um, are trying to do to, effectuate what their citizens want or their residents. So,
Right.
Yeah, I mean, I think one of the difficult parts about the home rule question is because the Ohio Constitution does include the language about unless a general law overrides it, no matter what, judges are going to have to determine what a general law is and how that can override local rules. Now, we could imagine a different constitutional framework in Ohio where you could flip that a little bit. And actually, local governments get precedent no matter what. And I've often thought about this question of you could have a system where the state sets the floor. So the state says, okay, this is the minimum regulation that you need across the state for oil and gas development. But local governments are free to go above and beyond that. That is a different framework that we could utilize. Now, our current constitutional language probably doesn't really allow for that, um, unless the state passed a law explicitly saying that. So the state could very explicitly say, hey, we're going to regulate oil and gas development in this way. And then the local governments can also do X, Y, Z. And that would be a perfectly acceptable framework. Right now, we don't really have a state legislature that sets up legal frameworks in that way on environmental issues. And so, as someone put in the chat, zoning is a form of a police power, and zoning, like local governments zone all the time. But if the state creates a framework for an issue, they can preempt that zoning power. So if it's a general law, if it's found to be a general law.
I was really interested in how something that is as boring in some ways as court administration impacts, clearly how quickly things move and some of the challenges. And so one of the things I was interested in is the specialized dockets and like, do you have ideas for specialized dockets? Do you have ideas you're advancing for greater transparency so that people could get the information so that they could follow cases more closely? Are there some like court administration recommendations that you both have?
Yeah, I mean, I think, well, so I'll give a few examples of how we actually do have some other specialized dockets in the environmental and energy context that I think give a little bit of an idea of what we could have. And I will say, though, there are pros and cons to them. So the Public Utilities Commission, the Environmental Review Appeals Commission, they are commissions set up to review certain types of cases that end up going to the Ohio Supreme Court. Or actually, I think ERAC, Environmental Review Appeals Commission, actually goes first to Court of Appeals and then up to the Ohio Supreme Court. But I bring up those two commissions because they're not courts. They're actually a agency, they're kind of pseudo agencies where the commissioners are appointed by the governor. And so they aren't elected judges the way that our courts are, but their cases are overseen by those commissioners who are making essentially legal decisions. I don't have as much practice at ERAC, but both Randy and I have been in many cases at the Public Utilities Commission, and those commissioners are acting like judges in the decisions that they're making. They have attorneys writing their cases and their opinions, and then those opinions get appealed up to the Ohio Supreme Court. And so, in effect, they are a form of specialized docket at the state level. And I think there's pros and cons to it because, one, they're very technical and difficult for a regular person to kind of engage with. But they also do create a lot more sophisticated decisions out of them than you might get out of a trial court.
And I think the importance too of those is exactly what you said, Chris. These are really hyper specific, hyper specialized pieces. And so you do get those others. The one good thing that happens in a lot of those cases is there are public comment periods. There are, in a rate case, for example, which I know I'm sure some of the folks on this have gone and testified in public. But they have an open hearing. You can always submit comments on the docket. It's not as easy. So there's a little bit of participation aspect there, right? But things like that, to Chris's point, that are not technically dockets, but are, kind of categories of cases go into a particular bucket, I do think are important. The Environmental Review Appeals Commission is, permitting appeals go there, and those are pretty broad. So to Chris's point, it's a commission. It's kind of quasi judicial, and then those can get appealed elsewhere. But I do think some of those are important. As far as court administration, I have been our Environmental Review Appeals Commission did have, and this goes back to the concept or the problem of not having enough resources. They did have a different system for their docketing. I'll be honest, it still wasn't easy to search, but the new one they've consolidated with some type of entity called True Filing that administers this for many states and many different types of courts. And so, my assumption is that's probably because it was a better price and they didn't have to manage it. True Filing does, but it's not user friendly either. And so, I think for transparency, for public knowledge, all those things, and ease of access, we really have to fund those properly so that Ohioans know what's going on in their backyard.
Yeah, and on the question about specialty dockets, if I could propose any others, I mean, if we had infinite money, which we don't, but if we had infinite money, I mean, honestly, in any court system, you really probably should have like a judge or a set of judges for each category of case. Like electing the criminal law judge or the environmental law judge that is overseeing those types of cases probably makes sense. Now, there are probably also downsides to that because then one of the reasons why we don't have judges, every case go to the same judge every time, is because you don't want people to necessarily be able to predict the judge that they're going to be getting. There's some balance to having, a little bit of a lottery. But once again, infinite money, then you could have your three environmental judges, your three criminal law judges, so on and so forth. But we also don't have an infinite money. So, yeah, I think if we had all the resources we wanted, I would definitely say specialized dockets all across the board for every type of topic we want.
Well, there is this question in the chat from Danny says, can anyone expand on how or whether preemption affects state versus home rule situations? And there's a conversation going on in the chat, but I wondered if either of you wanted to jump in and talk about that.
Well, the quick answer to it is that preemption is what the state is doing to a local law. So when we use the phrase preemption, we're talking about the General Assembly having passed a uniform general law. The oil and gas is a good example of this. The state has passed a comprehensive regulatory scheme for how oil and gas development occurs in Ohio, including how wells are permitted and all those sorts of things. That scheme is considered state preemption of a local government having the ability to create its own similar scheme for oil and gas development within that local government's territory.
And then I wanted to ask about this. I don't know if you were paying attention to the judges on the bus with the justice in motion, the rule of law judges. So there's a Maureen O'Connor and former Justice Donnelly, Michael Donnelly, and Yvette McGee Brown, and then Attorney General. So Rich Cordray was there for a while, and talking about kind of due process and rule of law and the importance. Can you tell us a little bit about kind of the environment and rule of law and how you see the climate right now?
Yeah, I think the most important thing I'm thinking about on the environmental area in the rule of law is it's actually a federal circumstance. So we have the federal US EPA has decided to change the endangerment finding for greenhouse gases in the United States, and they're proposing that greenhouse gases aren't endangering the people of Ohio. Sorry, the people of the United States. They've rescinded that rulemaking that they made back in, I believe, 2009, which it was fundamentally a scientific determination that the US EPA made. And so now there's litigation going on regarding that. And ultimately, there is a decision from the US Supreme Court back in I think 2007, Massachusetts v. EPA, that very definitively was like, greenhouse gases are a pollutant. And so that's what then the endangerment finding was built off of. And we now have a situation where those cases that are potentially moving through the courts, when that decision gets up to the US Supreme Court, we are going to have a situation where the Supreme Court could decide to just totally change that framework when it comes to greenhouse gas emissions as a pollutant in the United States. And when I think about rule of law and the environment, that's one of the most pressing issues in my mind is that we're in this situation now where judges are potentially making these scientific determinations and agencies can just flip-flop back and forth, and that doesn't really create the consistency that we need for legal frameworks in this country.
Randy, anything you want to add?
Yeah, I'll just build off of that. It's really concerning, just to Chris's last point. Our system of government, right, is supposed to function in these three branches, right? We're supposed to make the laws, we're supposed to interpret those laws at the Supreme Court, and we're supposed to implement those laws. And when we get judicial philosophies that are kind of meddling in places perhaps they shouldn't, we may end up with situations like this where the interpretation, if it makes it up to the Supreme Court quickly enough, just in it, goes ahead and implements everything that an administration wants to do. And that is not good for anybody. We sometimes think of the environment as, pitting business against the people. And I got to tell you, businesses don't want this flip-flop either. It's expensive for them to comply with law and then be able to, stop doing that. There are lots of instances where we've had something put in place and the companies are like, we'll just keep complying with it because we already spent a bunch of money on it, right? So consistency is important, and interpretation is part of that, right? And so an honest interpretation and following the rule of law is critical. And, it comes back to judicial philosophy, right? We're all people, we're all human. I think people are doing their best on these things, but policy creeps in. I don't care who claims that they're just reading the definition on the face, policy creeps in because we're all people. And so I think, trying to make sure everyone's keeping the goals in mind of a system like we have of government and staying in our lane with our three branches and making sure we're interpreting that properly is really important, but also really tough. So.
Well, we're almost at the end. I have one more question for you, Randy. And it had to do with standing, the versus, the individual standing versus class action. And how does that work? And what happens with a class of people all trying to prove that they had harm?
Yeah, I mean, you can show this broad brush, right? One type of a category of person, if that category of person can show they have harm, that is how you get a class certified, essentially. So it's a very similar standing test. But then if you fall into this category and are able to get that class certified, anybody in there, qualifies as covered by that particular ruling. So I don't know about you guys, but I get stuff in the mail that says I'm part of a class and I can opt out, and if not, I'll get $2, right? Um, so, that, essentially, if you're able to prove some of those same components that Chris walked through with standing, but that it is a class-wide basis, and you are able to get that class certified, then that's kind of how that process rolls.
And just to add on to that, this was a question in the chat, and Randy, I
I don't think
asked
I saw it.
for
Yeah.
you to answer this because you've actually done a class action lawsuit, I believe, back in your early days as an attorney. I have not done one, but there's this weird additional test for certifying a class, which is like if the number of people that could be included is like so numerous or whatever, which I think generally they're just like if it's over 100 people, then you can certify a class. But the person was asking about like environmental definitions for a class. And depending on the situation and the harm alleged, it could be everyone who lives in X town, or it could be everyone that's within 1 mile of this pollution event.
Mhm.
And then everyone within 1 mile could fit that class.
Yeah. Yeah, the numerosity is key, like Chris was saying. Otherwise, it could just be the 25 of you that this applies to, right? And you don't have to join that lawsuit. But if it is so numerous, and yes, to Chris's point on the environmental context in front, that's exactly right. So thank you for explaining what the question was, Chris, because I didn't see it in the chat.
And my apologies for saying it a little too generally. I just wanted to say a great big thank you to you both for walking us through things. I also just wanted to encourage folks to come to the next session and then be on the alert for slides, the recording, and all of that material. And I did want to close with some information so that you can reach out to Chris if you have a question. Anything you want to add here, Chris?
I think Jessica is putting the link in the chat right now, but for those of you who are seeking CLE credit, please fill out that form, and we will make sure to give you that appropriate credit. I'll email folks who are seeking CLE credit once we've finalized it, and just so you know that you're getting the credit. But yeah, I mean, hopefully you all join us next month, law conference in September. Really appreciated all the questions. There's been a lot of chatter in the chat, and I also appreciate that everyone's kind of talking to each other back and forth too. There's been some interesting conversation going on. So this has been good. Always glad to join the three of you as well. So
And a big thank you also from the Ohio Fair Courts Alliance. Any final words, Jessica?
No, thank you all so much for joining us. Again, where our final session in our summer series is on August 19th at 6 p.m. Registration is in the chat. Chris will be with us on that one, as well as Erica McConnell from the Environmental Law and Policy Center. I will put the link for the CLE credits. Again, I don't know that everyone got that.
We'll also include it in the follow-up so
yeah, it'll be
that
in the
don't,
follow-up
you know,
email.
don't worry if you didn't get it, reach out to Chris.
Yeah.
Yep. Here it is
And
again
with
as
that,
well.
a big thank you to everybody. I very much appreciate it.
Thank you.